supplementary costs list.
Any mentioning? Fast.
I beg to mention item number 5, my lord. I'm praying if this matter can be taken up after 2 weeks, my lord. This is that Nehu matter, my lord. I have informed the other side, my lord. Mr. San is appearing.
That will be 5-2.
5, 6, 7, my lord.
Then 8 is also connected then. Not here, I have been informed but not very sure that my client passed away. But I will confirm with that first.
Very unfortunate.
Very unfortunate. Anyway, but I'm not sure because I just heard from his grandson. The contact person was a grandson. I'm not able to get the grandson now. So anyway, I'll
just check.
1 week. In 1 week's time, I'll take that instruction.
Let it come after 2 weeks, my lord.
On prey made by the petitioner, not objected to by respondent. This is matter after 2 weeks.
Okay.
May I please, your lordship? I beg to mention item 12. Item 12.
Yes.
Lordship, I'm praying that this matter may come after 2 weeks.
On prey made by the petitioner, this is matter after 2 weeks.
Do badge.
Wait, please, your lordship. Lordship, item number 17 and 18. 17 and 18, my lord.
Yes.
My lord, if this matter can come, kindly come next week, my lord.
No objection, my lord.
Come after 2 weeks then.
Alright.
On prey made by the petitioner, this is matter after 2 weeks.
May it please your lordship, I beg to mention item number 15 and 16 as well, your lordship.
I think here we are almost done. Was argument from your side advanced or heard only from your side?
Twice, my lord.
So the first time around you couldn't hear properly, so you waited for the second time. Now that also you have forgotten, so you're waiting for another third round for the petitioner to refresh. Not necessarily the court, but you. I don't understand. What's your excuse now?
Your lordship, we need some more time, your lordship, in order to prepare the matter, your lordship.
You have filed your written argument as well, isn't
We
it?
haven't filed it yet. We are waiting for them to.
Fine. On prey made by the petitioner or the respondent, not objected to by petitioner. This is matter after 2 weeks. You know, so these are they are all connected matters, isn't it? 15, 16, 17, 18.
Lordship, I beg to make a mention item 3, Lordship. Pre-written matter may come after 2 weeks, Lordship. This conducting counsel is out of station.
Three weeks.
Lordship,
On prey made by the appellant. This is matter after 3 weeks.
simply prayer for item 11, Lordship.
Excuse me. What is item 11?
Yeah, and then for the union, Your Lordship.
You are in this case?
Yes, Lord. No objection. Your Lordship, this item, this Hilsiman. Sorry, Lordship. It's item 10, Lordship. My apology, Lordship. Item 10.
That is why I'm asking you again,
Lordship.
because your name is not there.
My apology, Lordship.
On premier by the petitioner, this is matter of 2 weeks.
Fully obliged, Lordship.
Excuse me.
May I please, Your Lordship? I beg to mention item number 13, Your Lordship. In this case, Your Lordship, there is little difficulty because I have not received the instruction from the petitioner yet. So I seek some more time, Your Lordship.
What is the matter about, Mr. Joshi?
Your Lordship, there we are disputing the pensionary benefit that was paid to us. We are disputing the amount that is.
Or you have already
Yes, Your
retired
Lordship.
from
We have
service?
received some amounts.
Oh, that
and yes, Your
that calculation part.
Yes, Your Lordship. That calculation one. Since the petitioner, he is quite aged and moreover he is having multiple health issues as well. So for that.
It's a matter of calculation.
Yes, Your
you could
Lordship.
do it yourself,
But-
also, you see.
Yes,
Why?
Your Lordship.
There's no need to adjudicate on matter. It's just a question of ascertaining, see, whether you see that amount is.
Yes, Your Lordship.
You are really entitled to
Yes, Your
the amount or not.
Yes. Let it come after 3 weeks, Your Lordship. I'll just finalize the calculation and then come back.
Have you talked to the other side?
No, Your Lordship.
Then, okay. On premier by petitioner, this is matter after 3 weeks.
Oblige, Your Lordship.
Supplementary cost list, item number 1.
May it please, Your Lordship. Your Lordship, praying if the matter can come at the end of the board, Your Lordship.
End of the board.
Item number 2.
May please, Your Lordship. Lordship, I could not appear yesterday, Lordship. 439 bail application, Lordship.
I think the last order was for Mr.
Yes, Your Lordship.
Have you case diary is here?
Yes, Your Lordship. I have the case there, Your Lordship.
So, Mr. Bora, tell me. Tell, please.
Lordship, may come to Annexure 3, page 24.
Page.
7th line from the top, that the accused Sri Thaksam Nawasingh was not found inside the vehicle, and on questioning the 2 persons named above, they stated that the accused Thaksam Nawasingh had moved towards Guwahati. On the mere statement of above named 2 persons, the accused Thaksam Nawasingh was detained and arrested without any contraband found from his possession. Nothing has been found, only because the quantity is commercial. The bail application of the accused was rejected by the trial court, and the contention of the petitioner is that since nothing has been found from the possession of the accused, he shall be entitled to go on bail. I would like to rely upon a judgment of the apex court, Lordship. Paragraph 7.
Yes.
However, we notice that so far the accused one, appellant one, herein is concerned, the contraband in question has been seized from his possession. In our opinion, the prosecution has established the case against the said accused, and the courts below have rightly convicted the said appellant. Whereas in regard to appellant number 2, it is the prosecution case itself that he was traveling in the auto rickshaw along with 3 other persons. The prosecution has not produced any material whatsoever to establish that either the appellant had the knowledge that the appellant one was carrying was the contraband or not, in any manner conniving with the said accused in carrying the contraband in absence of any such material. Second appellant only on the ground that he was found in the auto rickshaw. In our opinion, it is not justified. As a matter of fact, the courts below have rightly acquitted the other 2 accused on the similar ground. In our opinion, the benefit ought to have gone to accused number 2.
Therefore, the appeal, so for he is concerned, succeeds and same is allowed, and the appellant is in custody shall be released forthwith, if not wanted in any other case. However, the appeal for the first appellant is dismissed. So my contention is that since nothing has been found, he shall be entitled to go on bail on any conditions. And the prosecution has produced a case diary also. Lordship may go through the case diary if any material is there.
Yes, Mr. Shulai.
May it please your lordship.
So your main contention is because
Nothing has
nothing
been
has been
found.
found, so he is entitled to bail.
Yes, Lordship.
May it please your lordship. Lordship, what happened in this case? Two person and
Excuse me, Mr. Shulai.
lordship.
Can you excuse me?
Yes, your lordship.
Because I have a.
Sorry, your lordship. Yes,
That
your
would take.
lordship.
precedence,
Yes,
no?
lordship.
It will not take. We'll.
Lordship, yes, lordship. Yes. I'm sorry.
In the meantime, if there's
Lordship,
anything
I
that
have done everything, your
flagged,
lordship. I have done everything, your lordship. Please.
Daily cost list, item number 1.
In this case, I am the respondent. It is a petitioner to accept the appellant.
Who's the appearing for the petitioner? I think the last order says this is only for amendment of the cost cycle.
Yes, yes.
They have supplied as a copy.
Yes, sir.
He has supplied to yes, appellant.
Yeah, I have not received.
None appears for the appellant. This is matter after 2 weeks. Sorry for the interruption.
No, it's all. Mate, this is your lordship. Lordship, what happened in this case? Police received the information and then they set up a naka shaking. They got the information that some people they are assembling in one farmhouse at Lumkini, Umran. So, your lordship, what happened? Then they set up the naka shaking and 2 persons were caught along with the vehicle. And during the course of interrogation, they disclosed that another person is still there. He will be going to Kahati. So another naka checking has been set up, your lordship, and he was detained. That means the present accused in this case, the third accused, was detained, your lordship. And during interrogation, your lordship, they took the police to the farmhouse, your lordship, and the drugs was recovered, your lordship. They hid it in a tin box and hid it in the bush. That tin box was used in the farmhouse for keeping the curtains there, lordship. So that was it was his, your lordship. This is the second time, your lordship, this accused, your lordship, had brought the drugs, your lordship. And the first time, your lordship, he was very lucky, he was not caught. But this time, he was caught, your lordship. This drug, your lordship, were brought from Manipur, your lordship. Brought from Manipur in a car specially made for concealing the drugs. So, your lordship, from the investigation of the police, your lordship, revealed that he is a trafficker, your lordship, and for this, your lordship, he got 30,000 here. So, lordship, the fact remains that the drugs in this case, your lordship, in bulk, commercial quantity, your lordship. So, in my humble and respectful submission, your lordship, the rigor of section 37 would come into play, your lordship. And to that effect, your lordship, I would like to...
Let's read, that is well settled.
Lordship, yes. Lordship, a similar case, your lordship, lordship has dealt it. If lordship kindly come to para 14 of that judgment, passed by this court. Lordship, in this case also, section 29 and section 21 of the Act has been registered against these 3 people. Lordship, kindly come to para 14 at page 6.
Yeah.
May I read it, your lordship?
Please.
This court has given due consideration to the submission made by the parties and had observed that the offence alleged against the accused person is one under section 29 of the Act, which speak of punishment for abetment and criminal conspiracy as regard offence punishable under chapter 4 of the NDPS Act, section 21C being included therein, meaning that if an offence under section 21C has been committed, abetment of the same would carry the same punishment, and also that the RICO of section 37 shall also apply. Then lordship, kindly come to para 15. Section 37 start with a non-obstante clause to indicate that grant of bail which is in the norm is deemed to be affected in the negative. That is to say that bail is generally refused under this provision unless the court is satisfied that there are reasonable grounds for believing that the accused is not guilty of such offence and that he is not likely to commit any offence while on bail. Then lordship, kindly come to para 17. Or lordship, sorry, para 18, your lordship. In the case of so and so, your lordship, then that is the observation. And lordship, kindly come to the next page, the observation, your lordship. The scourge of drugs yield disastrous consequences on the health of young people, the well-being of the family, the spread of crime, and the destruction of economies by financial flow of obscure origin. The above remark, para 20, lordship, is aptly true in the society that we are now living, where the menace of drug is threatening to destroy life and society. Indeed, young people are most vulnerable to this threat and many a time have been seen to fall prey to the same. It is incumbent upon the society as well as God to combat this menace in whatever possible way, and although the process of law has to be followed in drugs-related cases, and the court has to be given wide latitude in napping or bringing any possible accused to book. Then, Lordship, recently also the Honorable Supreme Court, Your Lordship, if Lordship kindly come to para 14 of that judgment, Lordship, that is the observation, Your Lordship, of the Honorable Supreme Court with regard to section 37. Then Lordship kindly come to para 16. In view of the above provision, it is implicit that no person accused of an offence involving trade in commercial quantity of narcotic is liable to be released on bail unless the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence, and that is that he is not likely to commit any offence while on bail. The quantity of ganja recovered is admittedly of commercial quantities. Also here, Your Lordship, in this case is commercial quantity. So, Your Lordship, in view of the record of section 37 and the facts, Your Lordship, that there are reasonable ground that this accused has committed the offence, Your Lordship, my humble and respectful submission, the bail may not be entertained, Your Lordship.
What is the stage of the case?
Lordship is under investigation, Your Lordship.
Charge sheet has not been filed.
No, charge sheet has not yet been filed, Your Lordship. Whether Lordship will require this case diary.
Lordship, with regard to the position, may I like to rely another judgment of Odisha High Court?
Lordship, so far that recovery of possession, Your Lordship, that judgment also is in that bail application 22 of 23, Your Lordship, that paragraph 12, Your Lordship.
Just a moment.
Paragraph 12 of that bail application 22, Your Lordship, which the judgment passed by this Honorable Court. Lordship, that is the case of Union of India through Narcotic Control Bureau, Lucknow versus Muhammad Nawaz Khan, Your Lordship. Lordship, it says that absence of possession of contraband on the accused would not dilute the level of scrutiny required under section 37 of the Act. That has been cited, Your Lordship, in that bill application number 22 of 2022.
You're saying
that is page 4, paragraph 8. Fourth line from the it is submitted it in order to make the possession illicit, there must be a conscious possession. It is highlighted that unless the possession was coupled with requisite mental element, conscious possession and not mere custody without awareness of the nature of such possession, section 20 is not attracted. Next, paragraph 9, where the obdurcing judgment was elaborated. The word possession no doubt has different sets of meaning. It is quite elastic in its connotation. Possession and ownership need not always go together, but the minimum requisite element which has to be satisfied is custody or control over the goods. Can it be said on the basis of the evidence available on record that the three appellants, one of whom was driving the vehicle and other two sitting on the backs, were having such custody or control? It is difficult to reach such conclusion beyond the reasonable doubt. It is transparent from the evidence that the appellants were not only the occupants of the vehicle. One of the persons who was sitting in the cabin and another person sitting at the back of the truck made themselves scarce after seeing the police, and the prosecution could not establish their identity. It is quite probable that one of them could be the custodian of the goods, whether or not he was the proprietor. The person who were merely sitting on the bags in absence of proof of anything more cannot be permitted to be in possession of the goods. Earlier, I have given the another judgment that has been illustrated in paragraph 9. That is the Sorab Khan Gand Khan. Lordship, as such, that citation I have given earlier, the 2006, 2004-13 SCC 608.
It's not here.
It's there only.
You had given this
2004-13 SCC 608.
The one you give just now?
No, I have given earlier.
Earlier mean when?
Yeah, it's in the record only.
Do you have a copy with you?
Yeah, I do not have the extra Xerox copy. This is the.
Yes, this those.
That is.
This is not. No, this is the one you give just now.
No. Supreme Court of judgment. So.
I know only. You are referring to paragraph.
This is the judgment.
Paragraph 7 of this.
Paragraph 7 of the last paragraph.
Saurabh Khan.
Saurabh Khan. That with regard to possession.
Where's the evidence against the accused, Mr.
Lordship, it is.
You don't have a copy with you?
Lordship, it is.
There are so many flags here. I don't know
Yes,
what is what.
Lordship. From the stage of the investigation till the recording of the even his own statement also is there, Your Lordship. Let me assess Your Lordship.
Just point out, where do you find the complicity of the accused as far as the case is concerned?
Lordship, the plastic, flap.
What color? Blue?
Yes, Your Lordship, blue and red also. The plastic flap only, Your Lordship. Then his own statement also is there, Your Lordship, in that plastic flap.
Statement.
Any statement of the co-accused implicating the accused? Yeah.
Lordship, he also himself also he
has admitted.
Yes, Your Lordship. Lordship, in the Lordship in the plastic mark, Your Lordship.
Plastic mark? What is a plastic mark? Okay.
Lordship, yes. Yes, that is the one, Your Lordship. Naba, Your Lordship, is Tokbok Naba. It has been highlighted also, Your Lordship.
Yeah, Mr. Bora.
Yes, Lord.
Mr. M.K. Bora.
Yes.
Learned counsel for the petitioner, who has submitted that the petitioner herein is the wife of Sri Thoksham Nava Singh, an accused arrested in connection with Umsning PS case number 21-7-23 under section 21 C/29 of the NDPS Act. The Learned counsel has submitted that the accused person was arrested on his alleged involvement with seizure of a certain amount of alleged contraband drugs from 3 persons, and on the basis of information, the vehicle in which he was traveling was intercepted by the police, and accordingly he was also roped in connection with the said Umsning police, Umsning PS case number. At this stage, the only contention of the learned counsel for the petitioner is that the accused was not found to be in possession of the alleged contraband, and that he has no connection whatsoever with the co-accused who were arrested in this case. This being the case, he is therefore entitled to be enlarged on bail. As far as the aspect of possession is concerned, the learned counsel has referred to the case of Saurabh Khan, Gandhan, Pathan, and another was the state of Gujarat. So I took citation, and also the case of Kishore Bira versus state of Odisha. Ketua bangsa Ahmo citation at para 8 and 9 to say that the authority cited in this case is that when there is no evidence of possession, the accused person cannot be linked to the offence alleged against him. It is therefore prayed that this matter, that this petition may be allowed, and that the accused person may be enlarged on bail on any condition that this court may deem fit and proper to impose. Per contra, Mr. Indishulai, EAG, has submitted that at the outset, the case involved very heinous offence, inasmuch as the negative impact of the availability of drugs in society has a cascading effect on all concerned, for which it is incumbent upon the law enforcement authorities to put a stop to such a menace. As to the contention of the petitioner on the issue of possession, the learned counsel, learned AG, has submitted that firstly, the accused person has admitted to be involved in the said case when he has given his statement before the police. In any case, the section involved seizure of commercial quantity of illicit drugs, and accordingly the rigors of section 37 of the NDPS Act have to be applied. In support of his contention, the learned AJ has referred to the case of Sri Kup Lian Sum versus State of Meghalaya, wherein by the order dated 31/7/2023 passed in BA number 22 of 2023 at para 12, this court has clearly observed that I underquote, no, absence of possession of contraband on the accused person would not dilute the level of scrutiny required under section 37 under bracket 1 and bracket small b and bracket small 2 of the NDPS Act. The case of Union of India versus Ajay Singh alias Papu 2023 SCC online SC 346 was also referred to by the United Council, wherein the Honorable Supreme Court at para 16 of the same has observed as follows. In view of the authorities cited and the fact that the accused could not offer any plausible reason to satisfy this court that he is not guilty of the offence alleged, in view of the in line with the stated provision of section 37 NDPS Act, it is prayed that this petition, being devoid of merit, be dismissed. This court, on consideration of the submission made, has also perused the petition and has also gone through the case diary which was produced today. The authorities cited by the respective parties are also considered. What is apparent is that the accused person has been arrested in connection with the said Umsting PS case number 2, where seizure of commercial quantity of illicit drugs was made. Altogether, there are 3 or 2 persons arrested?
3, Your Lordship. 3, Your Lordship. The main accused is yet to be
altogether
tracked, Your Lordship.
there are 3 accused persons being detained in connection thereof. According to the learned EAG, investigation is still ongoing. Without ongoing. At this juncture, it is the considered opinion of this court that the investigation should be allowed to be continued to nab other persons who are involved in the case. As far as the accused person in question is concerned, his complicity has to be established. His complicity has been prima facie established, and accordingly the provision of section 37(1) Act DPS, provision of section 37 NDPS Act will be applicable. A bare reading of the said provision would show that a person arrested or accused of an offence punishable under section 21, punishable under section 19 or 24 or 27A, and also when the quantity of the seized contraband is of commercial quantity, such person shall not be released on bail unless the public prosecutor has been given an opportunity to oppose the application for such release, and more importantly, unless there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. This court, relying on the provision of section 37(1), 2, small 2 more, would say that the accused person in question has not been able to offer any reason for this court to believe that he is not guilty of such offence. In fact, if the submission of the learned AG is to be accepted, the accused person has also been arrested earlier in connection with.
Not arrested earlier, Your Lordship. No, he was never. First time he escaped, second time he was gone.
Was also suspected to have been involved in drug-related cases. This being the case, this petition is devoid of merit. The same is hereby dismissed.
Apply, Your Lordship.
Item number 3.
Mr. The CD is, you want to back?
Lordship.
Is it the original or copy?
It's a copy, but we'll take back, Your Lordship.
I know.
We'll take. Apply, Your Lordship.
Item number 3.
Supplementary. Yes.
This case come from the other court, my lord.
What's this case about?
Lordship, actually, in this case, Lordship, we've come before this Honorable Court, Lordship, challenging the illegal manner in which the land holding certificates were issued in favor of respondent number 4, Your Lordship. So, Your Lordship, I'll just take Your Lordship to the brief facts of the case.
What all the pleadings completed?
My lord, we have challenged the maintainability of the writ petition, my lord. So we have filed affidavit only to that
It's come
extent.
on admission.
So my lord,
We are challenging the maintainability of the petition, my lord. I am the private respondent, my lord, in whose favor, my lord, that landholding certificate was issued. We are saying that petition is not maintainable under Article 226, my lord. This is our stand. To that extent, my lord, she has to, my lord, that this petition is maintainable.
All the parties are in attendance.
Yes.
Some have not filed their affidavit as yet.
my lord, detailed affidavit we have not filed. We have only filed a short affidavit, my lord, challenging the maintainability. On the ground that, my lord, there is alternative remedy, they have to file an appeal before the judge, district council, my lord. Well, the matter can be heard.
Alternative remedy is available.
Yes, yes, yes.
That's according to you.
That's our case, my lord.
I beg to defer, Lordship. Lordship, this case...
Well, the matter is taken up next week, my lord. Today is the first time it's coming, my lord.
So affidavit have not been filed?
They have filed this short affidavit
Yes,
of maintainability.
affidavit as far as the merits of the case, but as far as maintainability is concerned, have you filed?
Yes, affidavit has been filed.
You have been filed.
Only by the district council, respondent number 1, 2 and 3.
And what were the others? And
the original owner of the land and the seller, and I have sued it to my lord respondent number 4. I have filed a single affidavit on facts as well as on.
I have also filed my lord. Respondent number 4 has also.
One, as senior said, this is an illegal order, as provided under this statute. Secondly, my lord, it is our case that it is my land, and it is their case that it is the land under the village. So the ownership of the land is under question, my lord. And under 226 that may not be.
ownership of the land.
The ownership of the very land is, we are saying that she has no locus to claim anything on that land because it's my land. I have the patta, I have the seal, and there is no challenge to these pattas and the seal.
Until the patta is challenged, my lord.
So you are the village Dorwar?
Yes, Your Lordship. The reason why I've come, Your Lordship, is that because in the year 1980, an agreement was executed between District Council and the village, Your Lordship. And as per the agreement, Your Lordship, the District Council was to take over the land for plantation of trees, Lordship, for maintaining the land. And the ownership will lie with the village. So now what happened, Lordship, that in spite of the fact that this agreement is still in existence, Your Lordship, so now I've come before this court because of the illegal action of the District Council. In spite of the agreement which still exists, they issued land holding certificate to the respondent number 4. So that is my case, Lordship.
Now, a private land, can a private land, District Council can transfer it to the Dorbar, my lord. This is a private land, I have this land holding certificate. And for the person whom I have purchased, my lord, he has the seller over the land.
We will examine the land tenure system.
Yes, my lord.
And we'll see.
So let it come on 29th, my lord.
29.
29.
We'll list it after.
Anytime next week.
Because we'll have to look at the board and see. So what, after 1 week, miss?
All right, Lordship.
All the parties are in attendance. It is submitted that the initial issue to be decided in this matter is with regard to maintainability of this instant petition. To this extent, the respondents have filed their respective affidavit mainly on the ground of mainly on the issue of maintainability. As prayed for by the parties, list this matter after 1.
Obliged.
From daily cost list, item number 1.
This matter is fixed for filing of rejoinder. I've examined their affidavit and I took some instructions from my client. I'm awaiting further instructions. I was hoping if Lordships will kindly grant me a week's time. I'd consulted this matter with my friends. If they have some difficulty with next week, they would pray for 11th. We've agreed on the date of 11th if Lordships, if it is convenient to my Lord. 11th of December, my Lord. December.
Oh, that's November.
That's November.
Oh, yeah. I'm looking at the testing my eyesight. On pre-made by parties, let's just matter on 11th.
Highly obliged.
Item number 2.
Lordship, no affidavit has been filed.
9, 10 and 11, my lord. I'm praying for some more time, my lord, for affidavit. Others,
I think last time we had established that they are,
my lord,
relevant parties.
necessary to file an affidavit.
On pre-made by...
My lord, Lordship grants you 4 weeks, my lord. In the meantime, I'll
it will
file.
go after vacation. So,
Go after vacation. What else?
Lordship has already given enough time
It's true,
to this respondent.
but then what if
And then, last order also, Lordship, goes that.
Complete adjudication is to be done. Then
That is, and but it has also been seen that whether there is a delay tactics followed by the respondent or not.
who will gain by that?
Respondent number 9, 10, 11 has.
Will they gain by delaying the matter?
Yes, Lordship, because
At the
it will
most, they
cause loss to the
at the
petitioner.
most, if it comes to that, at the most it will stall your right, but nothing more.
Lordship, this may be given a last chance since giving a
It's not proper to
longer
cast,
time.
Not proper to cast aspersion on the integrity of. We'll fix it in 3 weeks then.
3 weeks.
Dr. in Musica Leonard DSGI has once again sought some accommodation in this matter as far as filing of the counter affidavit on behalf of the respondents 9 to 11 respectively is concerned. Though the General Counsel for the petitioner has no objection to the prayer made, it has however submitted that the matter has been dragging on only on this point for quite some time. Be that as it may, in the interest of justice, this court would allow the said respondents to file their counter affidavit. As prayed for, this is matter to 3 weeks.
Item number 4.
This is an appeal, my lord, against the conviction, and then
May it please, Lord. My Lord, this matter pertains to the payment of interest on the gratuity amount. My Lord, I had given it.
Mekofet matter?
Yes,
Mekofet matter, my Lord. They are claiming interest, my Lord. Here, my Lord, before my learned senior starts, I would say what the bone of contention is, my Lord, on the interest. Now, according to them, since they have retired in the year 2004, they should have got their gratuity from 2004, and having not done so, they are entitled to claimed interest under the Gratuity Act in the form of a penalty. According to me, according to us, is that we have not deliberately withheld your gratuity amount. When the matter reached up to the Supreme Court to consider whether the Gratuity Act applies to Mekofet or not, when this matter went to the Supreme Court, and we gave an undertaking that we will pay gratuity to the people who are retired on VRS. Thereafter, my Lord, so immediately after that order, we have sought fund. We have paid from the day of the Supreme Court's order, my Lord. So according to them is no. They're saying that no, you have delayed since 2004, and according to us, we have not delayed your disbursement of your gratuity. Once the Supreme Court matter, the matter rests there, then we have paid to you. So that is only bone of contention. So which is the date to be considered? Whether 2004 or from the day the Supreme Court rests?
So perhaps the issue could have been clarified at the
Supreme Court.
At the Supreme Court level.
Yes.
As to the issue of interest.
Yes.
Payment, or more often than not, when a court passes an order on the submission of the parties, and particularly I think in that case it was a consent order.
Consent, my Lord. Yes.
So those conditions should have been there. If they are not there, it is assumed that it is not applicable.
Yes.
I mean, prima facie, we can look at that in that way. But then, of course, only thing is that if it is mandatory, statutory, then.
Because, my Lord, here in other normal cases, what I understand is, my Lord, yes, gratuity is not a bounty or something. It's
not a windfall in any
yes,
case.
Yes, once it is there, we have to pay. But our contention was that, and their clarification was also that payment of Gratuity Act was never applied to Mekofet. And in the past instances also, nobody was paid. The only grievances when they wake up is because when we have given them the golden handshake scheme on the implementation program implementation departments, saying that all the 6 PSU and PSCs, they have found out that because of overstuff. So they said they should downsize. So we downsize. Then the government of Meghalaya has given us as a standard format. Standard format, in the standard format, it was given that computation, how it has to be computed. And they said, so far as leave encashment and gratuity and these are concerned, they said as per the service rules of each PSUs and PSCs. So Mekofet, we are governed by the KAKA rules, Mekofet's rules, service rules. We have got our own rules. In our own service rules, we don't have the provision of payment for gratuity to anybody, and more so, it was never paid to anybody also.
But Mr. Yubin, I think this issue was agitated in those earlier, and it has been now laid to rest.
Yes, that has been raised to rest. So the court has held that yes, payment of gratuity is applicable to Mekofet. That is the only question answered. So we went challenging the Supreme Court. So now, whether that order, because they have never claimed, and even in those judgments, my Lord, where the court has directed, even the learned single judge before, and the division bench also, my Lord, never said. They only say that yes, payment of gratuity is applicable to Mekofet. They have not talked about interest, my Lord.
Yeah, Mr. The petitioner here. They were party in that case. Supreme Court.
Yes, they are the same party.
So they are the one who has benefited from that BRS.
Yes, yes.
So the order passed by Supreme Court pertains to them.
Pertains to them. Now, my Lord, I think if my friend has completed.
My Lord has rightly said, if they have any grievances, they should go to the Supreme Court and clarify. What do you mean by this?
If my Lord has done with, let me start, my Lord. Because my Lord, I have given my written argument. I have given my written argument in a precise manner. First of all, my Lord, Court has rightly said that now we confine our issue to the interest on the delay payment of the gratuity. Now, so far, the Act is concerned. Let me come to the Act. So far, the Act is concerned. Payment of
Act would be there. That's why we are not
disputing.
Provision of the Act is there.
Yes. No, my Lord, I'll
There's
come.
a provision for interest.
Yes, my Lord.
That is there. Section 7, isn't it?
Yes, we are not disputing that. And
Let
now
me-
we are not
let me-
disputing also that we are not.
Let me come to the. Let him.
Don't get too excited.
Yes.
Yes, Mr.
My Lord, of course, so far the Act is concerned, it provides for interest. Now the proviso of the Act. So far the proviso of the Act, it may be allowed to read. So far the proviso of the Act is concerned, it says, if I may allow to read, that is, provided that no such interest shall be paid.
You're reading section?
Section 3A, 7.3A. Section 7, subsection 3A. I'll just read it out, man.
Yes, a moment. What are you? Please.
Well, 3A. If the amount of gratuity payable under subsection 3A is not paid by the employer within a period of specified specified in subsection 3, the employer shall pay from the date on which the gratuity becomes payable to the date on which it is paid, simple interest at such rate not exceeding at the rate notified by the central government from time to time for repayment of long-term deposit as the government may by notification specify. Of course, that part is clear. Now the proviso. Provided that no such interest shall be payable if the delay in the payment is due to the fault of the employee. Due to the fault of the employee. This is very important. I'll come to that. How? And the employer has obtained permission in writing from the controlling authority for the delay payment on this ground. Now the first part is concerned. I'm not entitled to the interest if there is a delay on the if the fault. Now, then I come to in my written argument, my Lord. I think I've given the detailed written argument at page 2. My Lord, if my Lord comes to page 2 of my written argument. Lord, my Lord, I just have to confine as to the first part of the Act.
Yes.
My Lord, narration of facts attributable to delay occasioned by the respondent in the payment of gratuity. Under the head, narration of facts attributable
yes.
to delay delay occasioned by the respondent in payment of the gratuity. My Lord, the brief facts I've narrated here is that now how the series of facts that has led to the delay on the part of the employer. Now, at the first instance, when I was entitled to payment of the gratuity, I had approached the controlling authority. Section 10, Rule 10 of the payment of gratuity provides that in case gratuity is not paid, you can approach the controlling authority at the first instance. So, the controlling authority at the first instance, in compliance of the order dated 2610. 2610. Well, if I have made this written argument to a very brief, concise, and the details are there in my in the affidavit filed by them also. at the order dated 2/6/2010 that was passed by the elsewhere Guwahati High Court Shillong bench in writ petition number 52, wherein the said controlling authority, white order dated 30th/7/17 passed positive order or that the petitioners are entitled to payment. At the first instance, the controlling authority had passed an order that we are entitled to payment of gratuity. And that was also done at the BS after filing a writ petition and the direction issues. And then the order was passed by the controlling authority that I am entitled to the gratuity. Then subsequently a review was filed by the respondent, and when the review was filed, they took a U-turn. Then I am not entitled. I am not entitled to gratuity. Then after that, what happened that in disposing of that review petition, it took 2 years. And my in the paragraph B, that thereafter review petition was preferred by respondent against the order dated 37 before the controlling authority, and the said authority, after hearing the parties, rejected the stand of the petitioner, white order dated so and so, held by the petitioner, was not entitled. So, my lord, I have given in the affidavit in opposition that order is there. They are not. That took 2 years. Thereafter, against that order, now we had approached the Honorable High Court. Now it is of their doing that at the first instance, which ought to have been the controlling authority, which at the first instance allowed, and thereafter U-turn was taken. And
what you're trying to do, you're trying to establish that the delay was caused by the by the MECOFED.
Yes. Then thereafter, we had approached the Honorable High Court by filing a writ petition. I'll just confine because there were 2 issues. One was related to the leave and custody, and the other part was to the gratuity. However, as a matter of fact, both has been paid. But so far, this issue is concerned today, we are concerned confining our issue only to the matter related to the interest on the payment of the gratuity. So after filing of the writ petition 154, SH12, the impugned order was challenged, and thereafter that order was quashed by the Honorable single judge. When that order was quashed, and then direction was given for payment of gratuity within 4 months. And then thereafter, against that order, there was an intra-court appeal. And in the intra-court appeal, they had also miserably failed. Now, that took some time, that is around 3 to 4 years. After the failing in the intra-court appeal, they have preferred, in my page 3, in the paragraph F, have mentioned that they have preferred to file an SLP. Against that order, intra-court appeal, after the failure in the intra-court appeal, here, they preferred the SLP before the apex court. Now, there also, finding themselves unsuccessful, withdrew. And then the order was passed, dated 2/4/2018, wherein the order was in my paragraph G of that. I have stated that the Honorable Supreme Court had passed the order on 2/4/2018. That is where the respondent, number 2, that is MECOFED, agreed to pay the gratuity amount to the person who were part of the VRS. Now, that also took another 1 year. So these are the sequence of delay. Then thereafter, after that, so far the payment of gratuity was cut. That was paid in the year 2019. The gratuity amount was paid. We have received the amount. Then thereafter, what had happened? That now we have claimed here that we are entitled to the interest for the delay. So these are the series of conduct that no culpability can be imposed on us that we are delayed, that the delay has been caused by us. It is their doing which ought to have been done at the first instance, but so in exerting our right, we had to this series of litigation were preferred. Now, my lord, if I have also mentioned in the page 4 of my written argument, page 4.
Yes.
K, paragraph K is here. That is important. I just read it out. The petition says that an employee on their retirement becomes immediately entitled to pension and the other benefits. On the retirement of the employee as a duty is simultaneously cast on the employer to make payment of the retirement benefit to the retirer immediately on the retirement. It is self-position of law that the pension and gratuity is no longer bounty to be disturbed by the employer to its employee on the retirement, but have become under the direction of the Supreme Court in a Katinov judgment, valuable rights of the property in the hands, and any culpable delay in the settlement and disbursement must be visited with penalty of payment of interest at the current market rate till the actual payment. I mentioned that. Now, here, so far, other paragraph is concerned, Ms. Malad, I have already reiterated. Then, so far, this factual aspect is concerned. Then, Malad, if Malad comes to page 5, para, that is O.
Mr. Khan,
Malad, I have cited the judgment.
I may be wrong,
Malad.
but I feel that if at all you are entitled to interest,
yeah, Malad,
it would be only from the date of the order of the Supreme Court, 2018, till the date you actually receive the, the amount or the gratuity.
No, Malad, so far the Act is concerned, the Act specifies that from the date when the gratuity becomes payable. The gratuity became payable at the time when I had opted for that VRS scheme and I was made to retire. So there, it was very much in the cabinet memorandum scheme that other areas like gratuity, leave, encashment shall also be paid, which was not paid, and then subsequently we had to approach the controlling authority, and then thereafter there was a series of litigation.
But as we have said,
Madam,
you see that issue being there,
Madam,
was not raised at any point of time.
Madam,
even before the let's say before the single judge,
Madam,
before the division bench, and eventually even before the Supreme Court. So that being the case, like I said again, I may be wrong,
Madam,
subject to authorities from either side.
Yes.
But if at all,
Madam,
you are entitled to the only from the date of this order of the Supreme Court.
Madam. So,
but,
Madam,
of course, it's up to you.
So far, non-pleading of the interest at the earlier stage also, there is a judgment to that effect of our own High Court. I'll just read out the relevant part of our own High Court and the Supreme Court also, which I have mentioned. Well, that is in writ petition number 16 in Abdul Qazi Rahman versus GHADC. That one was rendered in 18/4/2017. I have enclosed, my lord. So the relevant para is at page 4, para 9.
Yes.
Sorry. Is at
yes, 4, 16, 18 and 19.
My lord. Page 4. That is a running page is 12. So if I may be allowed to read that para 9. Running page is page 12. This.
Yes.
That is the para 9. The petitioner, though not claim interest in the writ petition, however, while placing reliance on the judgment in the case of MS Champaran Sugar Company Limited versus Joint Labour Commissioner and the Appellate Authority and others, reported in AIR 87, 97, Patna 96, full bench. Learned counsel for the petitioner argued that the petitioner is entitled for interest as there was a delay in the payment of gratuity to him. The Honorable Supreme Court in the aforesaid case considered the question whether the Payment of Gratuity Act envisages the grant of interest on delay payment of gratuity to an employee and held that the right of interest on delayed payment of gratuity is a statutory and the same can be granted in the absence of an express claim, therefore, in the application of the employee. It was further held that if the basic claim of the gratuity accrues irrespective of any application or express claim on behalf of the employee. It is somewhat elementary that the consequential claim of interest for the delayed payment would equally occur without any express claim thereof. Then I may come to page 16, that is para 16, last part, the relevant part. Yes. Since the date of retirement is known to the respondent, well known to advance, there is no reason for them not to make arrangement for payment of retired benefit to the petitioner well in advance as soon as the employer retires. His retired benefit are to be paid on the date of retirement or within a reasonable time. Inaction and inordinate delay in the payment of retired benefit is nothing but a culpable delay warranting liability of interest on such dues, assigning the reason like the financial position of the concerned department or there is a financial crunch cannot be accepted and will not have the respondent authorities from the liability from payment of interest. My Lord. Yes. So, my Lord, this is the relevant part so far, even if interest is not claimed. Then I come to the other citation, my Lord, which is relevant, that is in support of that. That is Punjab and Haryana High Court. Again, my Lord, the relevant portion is at page para 10, page 22. My Lord. Yes, I'll just read here. Para 10. That is, the question so far is the question that arises our consideration is whether the retiree can approach this court under Article 22 of the Constitution to claim interest only on the delayed payment of pension and other retirement benefit. As observed earlier, there is a duty cast on the state to disburse the pension and retirement benefit immediately when it becomes due, and it is the non-performance of this statutory due which gives rise to the retiree to claim compensation by way of interest. This right to claim interest partakes the nature of the character of retired benefit and is indeed a concomitant of the right to claim pension and retired benefit and cannot be separated therefrom. This being so, a claim for interest by the pensioner cannot be equated with the claim for money simpliciter or any interest thereon arising out of contractual obligation. Moreover, in a claim for recovery, pension or other retired benefit which the state has wrongfully withheld, or even when the interest is claimed on these amounts, the plea of bar of limitation cannot be permitted to be raised because the state has defaulted in the performance of its obligation, performance of its duty in not paying the amount when it becomes due. In this view of the matter, it follows that when the retired government employee seeks the remedy by invoking the jurisdiction of this court under 226 of this Constitution to claim compensation and retired benefit by the issuance of writ of mandamus or any other direction, he is equally entitled to seek relief in the same way for claiming interest only on delayed payment, which is an enforcement of incident of the same right. It will, this is very important, enforcement of interest of the same right. It will of course be open to the state to plead and prove that there has been no delay, much less culpable delay on its part in disbursing the amount so as to entitle the retired employee to any interest as claimed by him. To put it differently, if a retired government employee can show that there was a delay in the payment of pension or any other retirement benefit to which the onus would be on the state to show that it is not guilty of any culpable delay, and if it is unable to discharge the onus or to satisfy the court as to the reasons for the delay, a direction to payment of interest for the period would invariably issue. My lord, this is the relevant part, and then I would,
Mr.
my lord,
Khan, what you have tried to establish is the fact that you are entitled to interest on delayed.
Yes, my lord.
That I
Yes,
think that is well said. Like I
yes.
said, see, the provision of the Act is very clear.
Very clear.
The only thing is under the peculiar facts and circumstances
Yes,
of
madam.
this case,
Under the peculiar.
whether it is applicable or not, whether you are entitled to or not, that is how you have to
Yes.
establish your case.
Yes. So far this judgment is in view of the judgment that the culpability that who is at default lies on the burden of the state now. That look here, we are not at fault, but who compel us to approach the honorable the series of litigation? It is they who have compelled. Had the controlling authority at the first instance given the gratuity, this situation wouldn't have arisen. So who is culpable? So the burden lies on them. So now they have to show that, yeah, we are not guilty. What are the facts? Do they have any ground to enforce and show that, yes, we are not guilty of that? If they can show, well, I have no claim. And if they cannot show, because the burden shifts, which the ratio of the judgment exactly speaks about that. And there are a series of judgments speak. So this is the main substance of judgment. A series of judgments I have enclosed, which speaks on the same line. So this culpability, the wrong, that who is at default, that is why the Act has given in the proviso, provided that if the delay, default is on the part of the employee. If there is a default in my part, I am not in. But if it is on that, so they have to show that, yes, we are not culpable. So that is the entire crux of the matter, which I want to stress before this honorable court, so as to enable me that, yes, we are entitled to payment. Irrespective, the judgment of our own High Court, which has relied on the Champaran case, has also said, irrespective of non-pay, we have not pleaded regarding interest. But since it is a statutory right, they have also pleaded that the principle of constructive res judicata. That is not applicable, because when the law contemplates from a payment of interest, question of this constructive res judicata also will not rise, if the law does not contemplate.
Yes.
Well, there are the other relevant. If I read out the portion of the judgments, of course, that more or less they speak on the same line. But in my written argument, I have mentioned the specific paras.
Yes.
So, if my lord wants that I should read those paras,
this court will go through it.
Yes, because the basic substance on the basis of which that I have just now read the portion of the judgment, it is on the same line. The different judgment that has been passed from time to time, it is basically on the same line. So that is why the proviso which has provided in the Act provided that. Had that proviso not been there, we would have limit only to the interest. That is why, unlike the case, my lord, that last time when I was arguing regarding the interest on the delay cost in the MSC case appeal, so far that there was no such proviso. But here there is a proviso. So based on that proviso, who is at fault? My question here is this, that we are saying that it is because of their act in not complying with the payment of the gratuity in the first instance, and subsequently which led to a series of litigation till the matter traveled to the apex court and back again, we were paid. So now who is culpable? They are culpable of the wrongdoing, and they have to prove, show that what is them, that they are not at default. My humble submission is that, taking into view all these aspects and the judgment that which I have cited, necessary order may pass for the payment of this, the payment gratuity.
My lord, in this 1.5 year of the experience that we have seen in the High Court, my lord, when my lord was sitting in a division bench with our retired His Lordship Justice Banerjee, when the petitioner or the appellant could not make up their case because they have to stand on the merit and on the law, then even the respondents are not required to call. Here, what my learned senior is trying to do is that the question that has fallen from my lord, he could not answer to that one. He is trying to shift the burden on me. First of all, you have to establish your case that whose fault or who's not fault. That's totally a different question here. It's not. We're not even going. Otherwise, then every person who comes to exercise their remedy in the court of law, we will say that they are at fault. Why did you go? Because that statute provides us, the constitution provides us. Therefore, we come to the court. So during this pendency, you cannot say that because of you we got delayed. In the first place, when they went to the controlling authority, they have not even made us a party. That controlling authority was heard an ex parte. They got an ex parte order.
That,
Yes, the first that my learned senior has referred.
37.
Yes, where my learned senior has referred, where he said that where in the year 30th of July 2010, controlling authorities order. That was an ex parte order. So we had
but that has been taken up.
That
on,
has been taken
that has
care.
been taken up on challenge before the court. So
Yes. So that period you cannot fault it at us because of you. Why did you go to the court? Because of you, we got delayed. You cannot blame on any person who is going to the court of law. Therefore, my lord, that submissions, my lord, what my learned senior has tried to, by bringing this sequence of events or the timeline, and by saying that because of you we got delayed, and because of your fault, submissions, my lord, has no legs to stand, my lord, and merits no considerations at all, my lord. Now, my lord, what requires to be considered is, my lord, which is the date when the payment of gratuity became payable to them. According to me, the matter went and rest in the Supreme Court, and that is the day when the Supreme Court says 02/04/2018. That is the day when gratuity becomes payable. Had we pushed, because, my lord, when we have taken, I'll just take very few backgrounds of why did we say that. Because, my lord, as we say that was some kind of 107 members and 95 who were before my lord. In fact, these are the people who has helped us to revive a dying group, my lord, a dying agency, my lord, my lord. So then, when we reached to the Supreme Court, we took a very conscious decision. I was briefing Mr. Hansaria, a senior advocate. He said that these people, because of these people, I think whatever you have revived now is because of these people. So why do we not do that? Let's give these people the gratuity. Leave encashment, we'll fight, let's give them gratuity. We took instructions and they said yes. Okay, as a one-time measure, let us give them the gratuity. Let's not fight anymore. So that is the day we give an undertaking to the Supreme Court. Supreme Court said that, okay, then you pay. And when did the order came? The order came on 02/04/2018. Now are they saying that from 02/04/2018, within 1 month did they receive or not? That is not the case. Had we not paid to them within 1 month from this day, then yes, I say that we will pay you interest. You are right. Because all these judgments which my learned seniors has referred, these are judgments deriving from some organization or some department which already have a payment of gratuity made applicable to them. They are deliberately or for some other fault, they have withheld. So that's why the court says that no, if you have withheld, you pay. That is a different case to us. We were not there. Gratuity, whether applicable or not, that question went up to Supreme Court. Therefore, my lord, in my humble submissions, my lord, we are not at fault. The day it became payable to them, we have paid. So nothing left for them to pay. Now, if they want clarification from the Supreme Court, let them go to Supreme Court. It is not for my lords today, because my lord have already passed an order. My lord has passed an order in the past, say that yes, payment of gratuity is applicable. That order was put to challenge. But then in that case, they have never asked for interest. They have never asked anywhere interest. Even the court therefore has never talked about interest. It says yes, applicable. The question is answered. Why is answered? Because you are a state. You are getting grant from the government, therefore you are a state. Therefore payment of gratuity is applicable to you, my lord. My lord, if now the consequences, my lord, if what my learned seniors is pleading, my lord,
Yes.
if at all that happens, my lord, if that at all that happens, then my lord, what happens? Then everybody who ever has retired, my lord, everybody who has passed retired from the inception of the organization will have to pay to them all this. Then the public policy, the public interest will be hit, my lord, because my lord knows I've stressed what is MECOFED all about, my lord. Here somewhere it is touching to the public interest also, my lord. And also, my lord, there's one judgment, my lord, which I would like to refer, my lord, though they have not raised this, my lord. This talks about the retrospective, because according to them, they're saying that they are right from 2014 or 2004, and an order came. After order, they should be paid gratuity. So according to this order, because the order said subsequently, though it has come, the order said that MECOFED payment of the act is applicable to us, therefore you pay there. So somewhere they are bracing on that. Just to cut that, just to clarify that, my lord, the Supreme Court in the case of reported in 2010 5 SCC 388, my lord, 388. It talks about the retrospective applications of the judgments, my lord. It talks about under what circumstances it will apply, my lord, or it should not apply, my lord. Paragraph 34, my lord, I would like to draw my lord's attention to paragraph 34 onwards, my lord. My lord, may I read, my lord, very quickly? Yeah. It is pertinent to note that while interpreting the judgment, public interest should be taken into consideration. In ECIL versus B. Karunakar, this court considered the factors which are to be taken into consideration while giving prospective operation to a judgment. When judicial discretion has been exercised to establish new norm, the question emerges whether it would be applied retrospectively to the past transactions or prospectively to the transactions in future only. This process is limited not only to our common law traditions but exists in all jurisdictions. It is therefore for the court to decide on the balance for all relevant considerations whether a decision which unsettles the provisions the previous position of law should be applied retrospectively or not. The court would look into the justifiable reliance on the previous position of the administration, ability to effectuate the new rule adopted in the overruling case without doing injustice, whether its operation is likely to burden the administration of justice substantially or would retard the purpose. All these factors are to be taken into consideration while determining whether a judgment is prospective or otherwise. The court would adopt either the retroactive or non-retroactive effect of a decision after evaluating the merits and demerits of a particular case by looking to the prior history of the rule in question, its purpose and effect, and whether retrospective operation will accelerate or retard the object of the judgment, the purpose of the old rule, the mischief sought to be prevented by the judgment, and the public interests are equally germane and should be taken into account in deciding whether the judgment has prospective or retrospective operations. It is well known that the courts do not make the law to prevent administrative chaos and to meet ends of justice. The taking into consideration all these factors, this court refused to interpret 96 judgment in a manner which would have given retrospective effect. It is clear from the tenor of the judgment and from the other background circumstances, more importantly in view of the decision of so and so, which is a statutory body, and the three-judge decision case intended to give its prospective effect. What they are trying to emphasize, my lord, is that leave it. Whether public policy, whether public interest gets affected or not affected, whether Macofed gets closed down or doesn't close down, doesn't matter. Give it to me my rights. Give it to me my interest. And that interest also when? That interest also where we have not defaulted in anything. Trying to, by force, trying to join to 2004. And when the Supreme Court has very clearly said a date, they are trying to overrun that date, try to interpret that date, and trying to say that no, Supreme Court said from that day. This is what they're trying to say. In other words, they're trying to mislead this court also, my lord. Therefore, my lord, when we looked into this, the case as forwarded by the petitioner, my lord, in my humble submissions, my lord, we have not defaulted. We have given them the dues, my lord. We have taken a very conscious decision. They have accepted with open arms, and only after accepting whatever they got a little bit mileage, and they come back and claim for the interest, my lord. Therefore, my lord, this is only an abuse of the process of law, nothing else, my lord. Therefore, it's a chance litigation, my lord. Therefore, my lord, this case has no merits. In view of this, my lord, I raise my submissions, my lord.
State Lordship will adopt the submission advanced by the Macon.
Have you filed your written argument?
No, my lord. I'll just give a pointers, my lord. Today itself, I'll give a pointers, my lord. Actually, I have a pointers, but I'm sorry that I have to make some marks here.
Do it within 2 weeks then.
My lord, my lord.
1 week.
1 week, my lord.
One clarification, which it just slipped out. So far, the payment of gratuity is concerned. In fact, it becomes applicable on the date of retirement. My lord had raised a query. So the day on which the scheme get
no, that is again that is established.
Yes,
it's common.
Yes, sir.
It's common knowledge. The only thing is, you see, again, I will raise that query that in the facts and circumstances of your particular case, when the matter was agitated before this court and when right up to this Supreme Court. So that period,
correct,
whether it is to be counted or not.
Definitely, my lord, because
whether there is a specific,
yes, my lord,
whether there is a specific order by the Supreme Court to that effect.
Yes, my lord is,
since the Supreme Court is silent on that, whether it is to be reckoned or not.
My lord is very correct, my lord. So far, this issue has it, but so far the vital question is that who has made us to drag us up to the Supreme Court? Who is culpable to drag us to? That's what the judgment has clearly emphasized. Who has dragged us? What prevented them not to pay the amount at the first instance by the controlling authority? Had they paid, matter would have. They took a U-turn, and then after that, the series of litigation. That is that has to be taken over.
The argument of the parties. The petitioner has already filed his written argument, apart from the oral argument advanced before this court today. Mr. P. Owen, National Counsel for the respondent number 2.
3, my lord.
Respondent 2. Number 3.
2, I'm sorry.
Respondent number 2.
My lord.
Has submitted that he may be allowed to file his written argument. On pre-made, this is matter of 2 weeks.
My lord. Obliged.
Item number 11.
This is that matter, my lord, unauthorized use of the electricity, my lord, in the Dorbar. My lord, the matter was previously heard at length, and an affidavit has been filed by them showing that yes, we have complied with the code. So it is for me now, my lord, to show that they have not completely complied with the code.
Yes, that I think that if I remember correctly, that issue of notice has come.
Yes, my lord, yes. So now they have filed an additional affidavit showing that
actually received notice or not.
Yes, my lord. It will take a bit of time, my lord. So and my learned friend is also not here. We can have it sometime next week, my lord. Next week or 2 weeks, 3 weeks.
2 weeks.
2 weeks, my lord.
on pre-made by the parties. This is matter after 2 weeks.
Deeply.
Item number 14.
Maybe please, Your Lordship. This is a case, Your Lordship. The petitioner, she got a MA in philosophy from CMJ University. Your Lordship.
Your Lordship, I'm praying for 2 weeks' time on behalf of the respondent number 3 and 4. The conducting counsel, D.K. Datta, he's not well.
In fact, I want a direction to reconsider my case. Only that, nothing more. By the government.
But he's
the government actually is there because
the council is not there. 2 weeks time. Accommodation is sought for on behalf of the respondent number
3 and 4.
3 and 4 on the ground that the learned conducting counsel is indisposed. On pre-made, this is matter of 2 weeks.
I love you, Your Lordship.
Second call from supplementary cost list, item number 1.
But here, my lord, we are aggrieved by Annexure 5, my lord. I'll just take your lordship to Annexure 5, that is at page 68, my lord, translated copy. Page 68, my lord. This is issued by Durbashnong Mairunghe, Right Mabu, Milliam Simsi, my lord, to the petitioner, my lord, Kong Sainara Nongbet, Jaya so and so. Madam, by this letter, we beg to inform you that the village Darbar, Mairunghe, held on 7/8/23 has unanimously held as follows. We have thoroughly deliberated and discussed about the case filed by you against the village Darbar, Mairunghe. Today, the Darbar has discussed about the professional fees for engaging a lawyer. We have calculated the fees since the beginning until date, which amounts to rupees 10 lakh, for which you are liable to pay. And if you refuse to pay, the Darbar will have to resort to some other alternative. Number 2, my lord, the village Darbar has conditioned that for smooth functioning of the Darbar, you shall amicably settle the matter with your family members, that is Palmira Nongbet, Anu Nongbet, Tarakor Nongbet, Wanla Maker Nongbet, and Rayakor Nongbet. The village Darbar has resolved that you shall surrender to the village the spring water source around 5,000 square foot, and this is the penalty imposed by the village Darbar. The village has resolved that until you have settled the matter with the village Darbar, you shall not cultivate the said land. That till the matter is settled, you are restrained from visiting Mairung, which may result in untoward situation for which the village Darbar will not be responsible. My lord, the action of the Darbar, my lord, here what happened, my lord, the petitioner has inherited a plot of land, my lord, which falls within the jurisdiction of this village, my lord. Now, some family members of the petitioner, my lord, the cousins, they started claiming ownership of land, my lord. So the petitioner has filed a civil suit before the district council court, my lord, to establish her for a declaration, my lord. Now the suit is mainly directed against her cousins who are disturbing her position, my lord. But village Darbar, being the authority, we have implicated village Darbar also as a defendant in the suit, my lord. Now against that, my lord, the village Darbar had passed this order that you have to pay 10 lakh rupees for, because they have to engage a lawyer, so that fee we have to pay, and the phenomenal amount of 10 lakh rupees, my lord. And
so lawyers are earning that much nowadays.
My lord, the name of the lawyer, my lord, if I can just point out, my lord. So that is not our concern, my lord. But in any case, my lord,
yes, please.
The 10 lakh rupees, my lord. And basically, by this letter, there is a order of externment from village. I cannot enter the village, my lord. When I own the land, civil suit is pending before the trial court, my lord, and village Darbar is passing this kind of order, my lord.
Who is appearing for the?
Lordship,
my lord, we have served the state government, my lord.
I am appearing for the R5, your lordship. Only I would like to point out, your lordship, para 9 and 11 and defect are there, your lordship. In para 9 and para 9 and 11, Your Lordship. If Lordship kindly come to second line from below, Your Lordship, before the respondent number 5, it cannot be before respondent number 5, it should be respondent number 4. Then Lordship kindly come to para 11, respondent number 5, letter number, so Lordship, R5 is the police, Your Lordship, we have nothing to do.
That's a type of, it should be R4, my lord. We will do that correction.
Then,
My lord, we will take steps for notice on my lord 1, 2, 3, and 4 and 6, my lord.
Lordship, so far it appears, Your Lordship, from the inquiry conducted by the police, Your Lordship, so far the FIR filed by the petitioner, that petitioner has concealed the fact. Some fact has been concealed, Lordship.
Whatever the case may be, you see a bare perusal of that impugn order.
Lordship,
what does it imply? It implies that the village Durbar is a law unto itself.
I'm not on that, Your Lordship. So far, that fees is concerned, Your Lordship. In fact, there was a meeting on 26/6/2023 between the petitioner and the village Durbar, Your Lordship, where it was verbally agreed that she will pay the fees. That is, the police inquiry is here, Your Lordship. If Lordship would like to see the police inquiry so far, because there is an FIR lodged by the petitioner at page, Lordship will find it at page 71, Your Lordship. Inquiry has been conducted, Your Lordship, and then non-FIR case, Your Lordship, and 12/2023 under section 107 has been registered and will be submitted, Your Lordship. That is my part, Your Lordship.
So you take steps for.
My lord, only thing, my lord, the restraining me from entering the village, my lord, when I own the land there. My lord.
Anyway, this impugn order will be.
My lord, statement.
Heard Dr. N. Musika, Learned Senior Counsel for the petitioner. The respondent number
5.
You are 5.
I 5, Your Lordship.
5.
Yes.
Yeah. Respondent number 5 is represented by Mr. N. Learned AAG. As such, no formal notice is required to be issued upon such respondent. As to the other respondents, that is respondents 1, 2, 3, 4 and 6 respectively, the petitioner is directed to take steps for issue of notice upon them, the same returnable within 2 weeks. On the prayer of the Learned Senior Counsel for the petitioner, and on consideration of the submission made before this court, the impugn communication dated 13/10/2023 at Annexure 5 issued by the headman and secretary Mairong Village, Right Maungbo, Milim Sipship, River District, upon the petitioner hearing, enclosed as Annexure 5 in this petition is hereby stayed until further orders. Since the same is an ex parte direction, the concerned respondent is allowed to file an application for modification or alteration of the order to this extent. Dr. Musika has also submitted that in this petition at paragraph 9 and 10, typographical error has occurred in as much as reference to respondent
5 should be 4, Your Lord.
Should actually be
R4
referred to as respondent number 4. The petitioner is allowed to correct the same.
Para 9 and 11.
Para 9.
Lordship.
This is matter to 2 weeks.
Only your lordship, so far the FIR is concerned, your lordship, the police had taken necessary steps. They have caused
That
the
you
inquiry, lordship.
file your counter affidavit.
Only that part, your lordship,
You can do
because
that.
it is
And they will also, you see, if steps have been taken by you, then they will also, report
107 proceeding will be submitted before the court concerned. your
whatever the case may be, it is incumbent upon you once an FIR is filed to take
We have
necessary
done.
steps.
That's step we have taken.
If you have done
your
it, I
lordship.
don't
We
think they will
caused
have
an
any
inquiry.
grievance against you.
That's why, your lordship, I made the submission on the basis of the material available with me.
So please do that.
Apply, your lordship.